We are ready to start our second panel of the day. And to start us off, we will have Dr. Jessica Lai give an introduction. All of the bios of panelists are in the conference materials linked online. But I'll just briefly introduce Dr. Jessica Lai with regard to the work that she's done relevant to this particular panel. She specializes in intellectual property and especially patent law and patents and gender. And Jessica is also the author of Indigenous Cultural Heritage and Intellectual Property Rights and Patent Law and Women, as well as Patent Law and Policy. She's also the author of the Annotated High Court Rules, as well as numerous articles and chapters, and the editor of multiple books relevant to Indigenous peoples' cultural heritage. So Jessica, I will turn it over to you, and thank you very much for organizing the panel and for introducing us to Indigenous peoples' cosmologies.
Thank you, Sandra. Hello, everyone. Thank you for either getting up very early or sticking around in your evening to listen in on this panel. So this panel is about how Indigenous knowledge systems, and in particular, how the way that Indigenous peoples relate to nature and things can be property analogs. So more specifically, it's about how Indigenous relationships to things and their laws that regulate these relationships can serve the same core functions as Western property laws. Because after all, like Western property laws, Indigenous relationships with things are shaped by rules regarding who has rights to do what and in what way. So it's really an honor to be able to open and chair this panel of my highly esteemed peers. So in doing so, I am highly conscious of the fact that I'm myself not Indigenous. So I'm very much an outsider in this space. And what this means is that when I speak, I do so reflecting my own perceptions and understandings of this era as a Western educated Asian woman of color from New Zealand. And I have the privilege of being able to speak from the whenua, or the land of Te Atiawa, Taranaki Whānui, and Ngāti Toa. So I've been researching in this area of Indigenous knowledge and intellectual property rights now for a few years, and several years really. And something that has increasingly bothered me is just the narrow scope of the discussion, if there's any discussion at all. So my experience is that the interface between Indigenous knowledge on the one hand and intellectual property on the other hand, it's either just unseen by practitioners or ignored by academics. And when it is discussed, the rhetoric is largely, well, how could Indigenous peoples use the existing intellectual property system? Or whether we could build a neighboring Western construct to meet Indigenous concerns. So the rhetoric is very seldom actually, how does a particular Indigenous group govern its intellectual things? And how could we go about recognizing and respecting that system that they already have? So another way to view this is that the rhetoric is often about how Indigenous peoples can conform to Western norms, rather than how we could acknowledge Indigenous norms as existing laws. So in the next few minutes, I want to briefly talk about why it is that we commonly struggle to see Indigenous laws governing the intellectual as analogs to Western intellectual property. So to do this, we need to step back and look at the typical Western perspective of Indigenous ways of knowing and Indigenous ways of creating. So underlying the common inability to see Indigenous knowledge systems as regulated by laws is the fact that the Western world often acts from the starting point that there's one cosmology. There's one kind of science, there's one way of observing the natural and physical world, and there's a narrow range of acceptable ways to explain these observations. So cosmology is just, it's philosophy, it's science relating to the study of the physical world. It's about the origin and structure of the physical world and how it has evolved. It involves both observation and theoretical developments. Essentially, like any science, it's about observing things, explaining them, often through scientific theory. So the Western world tends to view its cosmology as reflecting objective truth and the only way of seeking objective truth. So put differently, Western societies view subjects like chemistry and physics as the only valid means to find truth in an objective fashion through their particular methodologies of observation, experimentation, and explanation. Now, within those methodologies of Western science, there's a disconnect between nature and culture. So what I mean by that is humans are culture who are separate from nature, and being separate, they're the ones who observe nature, and they're the ones who can master nature. There's a culture-nature binary. And this binary, actually, in Western science and Western societies really, explains why we often struggle to see indigenous knowledge as scientific. And the reason for that is that this binary often doesn't exist in indigenous cosmologies. So it's commonly said that the cosmologies of indigenous peoples are holistic. So they see things holistically where Western societies would see things in a discrete way. So an example would be for creative expressions. The rights and obligations around these are often tied to observations of the natural world and to explanations of the natural world. And these explanations are often tied to creation stories, which then regulate relationships between people and things and surroundings and so on. So as I said, another way to view this is that indigenous peoples don't have a stark distinction between nature and culture. Humans are not framed as something distinct from nature who are simply there to master it. Instead, indigenous cosmologies often place people in relations with nature that creates obligations as well as rights. And these rights, these obligations, can extend to what we would call inventions and works in the IP world. So that there's no nature-culture binary in indigenous cosmologies, or that there often isn't, can result in the presumption that, well, they haven't created any objective knowledge. They've just created subjective experiences and beliefs around those subjective experiences. So the Western lens then prevents us from seeing indigenous knowledge as being scientific knowledge. And the counter arguments, obviously, as many of us would say, there's actually no such thing as purely objective knowledge, because all observations are biased through our existing lenses. And even scientists will concede that there's an observer effect, that simply by measuring something, by observing it, we can affect it. Moreover, scientists talk about how science is underpinned by scientific theories, to explain their observations. So scientific theories to explain observations. This isn't really different from beliefs, in quote marks, to explain empirical observations. But if indigenous knowledge isn't considered scientific and their ways of knowing aren't considered science, it can become invisible to the intellectual property system, which is designed to recognize Western constructs of science and creativity. Moreover, it can mean that indigenous peoples are not viewed as scientists, or they're not viewed as people worth working together with. So Amanda has actually done quite a lot of work on this to flip this narrative and what she calls the marginalization of indigenous knowledge. So she's canvassed multiple recent examples of when New Zealand, the indigenous peoples of New Zealand, when their knowledge has been used to address current problems. And in a similar vein, Haiyan, also on this panel, has interviewed over 50 knowledge holders in Samoa and has published about their attempts to commercialize Samoan knowledge. And I'm keen to hear from both of them about their observations about of the interactions between the knowledge holders on the one hand and those who want them to use the knowledge, commercialize the knowledge on the other hand. And in particular, I'm curious to hear from them about how the intellectual property side of things has played out in those interactions. And I'm keen to discuss this when we enter into the discussion phase, because if we don't view indigenous peoples as scientists and their knowledge as science, it becomes much easier to appropriate that knowledge. To illustrate, if it's not science, then indigenous knowledge might not form part of the prior art for patent law purposes. Or as I said earlier, Indigenous peoples then might not be viewed as valuable research partners or as co-right holders. The monocultural construct of creation can also mean that the definition of what is infringement and also exceptions to infringement are potentially ill-fitting for Indigenous peoples and their cosmologies because they don't reflect Indigenous cosmologies. So for example, copyright protects the expression and not the idea, whereas Indigenous peoples actually might be more interested in the latter. Or as Trevor has written about, a fair use per US copyright law could actually potentially be a means of cultural appropriation, as it doesn't sit well with the Indigenous ways of regulating their creations. So in the intellectual property space, my observation is there's very little willingness to accept Indigenous cosmologies and philosophies and sciences at the foundation of how we theorize intellectual property. Yet what struck me in recent years is that there is kind of a willingness to do this, to appropriate these cosmologies and philosophies when it's beneficial. And I've observed this largely in the natural rights movement dialogue, where we often see that certain Indigenous perspectives will be used to bolster arguments for rights movements around nature. So that is, Indigenous perspectives can be used to show alternative ways of relating to things when it's convenient. And so this has made me wonder, could the same thing happen in intellectual property? But would we want it to? Because Indigenous perspectives are often used in quite a romanticized way. And they're often used in a way that ignores that Indigenous peoples aren't homogenous, quite the opposite. And I know that this is something that Virginia has written quite a bit about, and I'm keen to talk to her about this in our discussion part as well. So the tendency to homogenize Indigenous peoples, I imagine, results largely from the fact that non-Indigenous peoples want things clear and easy. You know, they want a template to know how to engage with Indigenous peoples. They want clear rules about what they can use, what they can't, clear pathways of whom they should consult with. But as Hyen has written about, these templates can result in miscommunication, unrealistic expectations, and ultimately neither party actually achieves what they want or what they're concerned about. So I've raised many themes, and I'm hoping that we'll come back to all of them over the next hour and a bit. But I'll end by reiterating that, like IP uses property to regulate relationships between people and intellectual things, Indigenous cosmologies can analogously explain the relationship between people and the intangible. But what happens when these worlds collide? You know, historically, the colonial process has meant the domination of one over the other. But can we move beyond that into a decolonized space where we recognize and respect Indigenous relationships with things and the laws that govern those relationships? Okay, so I'm going to hand the virtual floor over to Trevor as the first panelist.
Well, thank you so much for that wonderful introduction. And I'm excited for the conversation. Especially want to thank Sandra and Sean. They're at the Center for Intellectual Property and Innovation Policy for hosting all of us. And of course, thank you, Jessica, for moderating, and for my co-panelists. And I'm very excited to hear from everyone here. So let me start out just by sharing a little bit of a story. A number of years ago, I was speaking with an elder from my home village out on the Hopi Reservation, where I come from. And he was telling me that we were talking a little bit about music and about why our community is so musical. And I'm being a trained musician, that was kind of a theme that I had always been thinking about. And I told him that I was interested in knowing why Hopi people even started creating music. What was the purpose behind it? And, he stopped and paused, and then he said, well, no one just sings out here. And, I didn't quite understand what he was trying to tell me at the moment. Hopi people do a lot of singing, actually, for fun. Our Hopi radio station is always playing songs from local singers and songwriters. We have many people that are talented in reggae, hip hop, you name it, right? And our local music venues feature awesome artists like Casper Lamayesva and Ed Caboti. And this elder's answer kind of took me aback. What did he mean that nobody actually sings out here? Or nobody just sings out here? Well, as it turns out, Hopi songs, or Tatawe, are more than just an art form. Hopi songs have sophisticated poetry, they have complex melodic shapes, they have complex rhythms that make them really creative, probably by any standard. But after many years of working in my own community, working with composers or Yeyiwat in our community, I was beginning to get a sense after a while that these kinds of songs are actually doing more work on Hopi lands than just giving people this kind of a personal sense of enjoyment or aesthetic satisfaction. And I think this elder's response confirmed that to me. As it turns out, our songs function as a vital link between our people and other living things in the cosmos. And so creating and performing and circulating and remembering Tatawe and what we might call what we might call acts of sonic sovereignty, kind of a mode of authority that's drawn from these ongoing relationships between people and the land and other actors in the world and beyond. And these types of sonic relationships or expressive relationships have real impacts on the world. They and other kinds of expressions of this kind of indigenous sonic sovereignty have a distinct ontology or a mode of relation and existence in the world. And because of this, our Hopi laws governing Tatawe and other forms of generative expression have different kinds of protections under specialized laws and protocols and even standards of care that we use to govern them. So to this point, I recently interviewed one of our Hopi Kikmungwe, or a village leader in our language. His name is Liwen Lomayestewa. And he explained that our Hopi songs are not just for us Hopi people. It's for all the little insects that crawl the earth, for the animals, for the plants, for the birds, for the butterflies, all the people that live on the earth, even the stars and the galaxies. And it turns out that Tatawe help encourage things like rain clouds and humans and plants and animals to work together for the good of the world. They provide us with health and with wellness. They generate our sovereignty, as I mentioned earlier. They're sometimes direct representations of the law. In some cases, the lyrics of them are legal texts. Hopi songs, at the same time, also create a kind of sovereign sensibility within the people that listen to them carefully, because they connect us in that moment that we hear them with our territory and with our relations there. They sometimes carry out judgments. They sometimes organize us socially in different ways. They give us knowledge of who we are and also where our people have been, and they also illustrate our visions for the future. In fact, we call our composers of Tatawe, we call them Yeyiwat, or a term that encompasses concepts not only about artistic creation, but also strategic planning. So because of their unique attachments and their relationships, their visionary properties, they're governed by very different kinds of rules than aesthetic objects or purely aesthetic objects like music or literary works or dance or even recordings. To give one example, the use of certain kinds of Tatawe may actually require special kinds of training or even preparation to be properly cared for so that they don't cause harm to other people. One elder in our community, Leonard Talaswaima, recently shared this at a food and agriculture symposium that I was at. He said, some of the songs that people sometimes sing without the knowledge of their sacredness might run into difficulties in their lives. And we call these kinds of songs utihihi. They should be handled with care. And only people that should handle them really need to handle them. They have this kind of a wuvape, kind of a metaphorical whip. And anything that happens to somebody who misuses them is part of that. Even though authorized people sing them in public, most of us shouldn't be singing them unless we have that authority. Now, at the same time, Hopi people also often avoid privatization of songs and sonic creativity in our traditional way. Privatization of Tatawe or Hopi songs disrupts the kinds of incentive structures that are in place to help us create and generate new forms of sonic expression. Tatawe aren't typically owned exclusively. They typically aren't owned by an individual, but they're usually owned inclusively. They bring networks of people and environmental actors and other entities into productive relationships, which leads to natwani, or bounteous harvests, to community prosperity. This is really distinct from European descended creative models where individual capital accumulation is used as kind of a carrot for creativity. And as somebody creates, they're rewarded with this right to exclude others from using the work that they've created. They can then go and sell off that monopoly or that right to exclude in exchange for money. And then that encourages them to disseminate the work more broadly to maximize their monopoly, right? But in the Hopi model, our creativity, our modes of creation incentivize everybody to contribute their good thoughts, their labor, their resources, because everybody benefits when good songs are performed with a good heart. The composers are incentivized to go out there and produce more songs to share without even the need of personal remuneration. And sometimes we're even encouraged to outdo one another to compose the best songs that will bring about the most community prosperity. Now, the need for appropriate care of our songs, our oral histories, our traditional knowledges have led us to create, and also other tribal nations and indigenous peoples around the world, we've created laws and protocols and standards of care. Some of them are written, some of them aren't written, but they're there to govern the sonic world or other aspects of the world that involve this kind of connection. Our Hopi common law rules, at least some of them, that govern things like recordings of our traditional songs. Some of them are listed here on the slide. Some of our songs are considered nasimokyata or tu at akmongvistoti. This basically means that they're eligible for use by those that hear them, so long as they're used under our protocols and not for self-serving purposes. Other kinds of songs are mewanpi. They're material that can only be used with authority. Some songs actually have been purposely forgotten by our community, and the recordings, at least according to some elders, should be destroyed. And then finally, others are commercial material. They can circulate under normal copyright law. Now, Hopi people have recognized that others outside of our community may not understand these types of rules. And so our tribal council passed a resolution in 1994 that declared all sorts of ritual, ceremonial, and religious knowledge that's been recorded or fixed in a tangible medium outside of the control of our membership or our bodies. That's been deemed our cultural property. And by using this European settler notion of property, we're basically telling people, look, you understand property, and you understand that in order to access somebody's property or to use it, you have to obtain permission first. Well, that's what we're going to require of you. If you want to access our ritual, ceremonial, and religious knowledge that's contained in a recording, you owe us at least asking our permission and getting that consent. And so we have this law. These laws are generally enforceable in the US, at least on tribal lands, even against non-tribal members. Their enforceability off tribal lands may be more challenging. Other tribes in the US have also passed their own intellectual property codes and laws. This one is an example from the Pasquayaki Nation. They protect things like knowledge of remembered histories, details of cultural sites and landscapes, sacred property, knowledge of plants and animal species, and even knowledge of their own language. And they have really serious remedies, right? Anytime you excavate or desecrate unauthorized research or collecting or filming of these will require you to restore these, repair them, and then figure out the culturally appropriate disposition of them, or essentially rematriation or repatriation. I'll just end by saying that recognition of our indigenous intellectual property, traditional knowledge, traditional cultural expression laws, protocols, standards of care, all of these are integral to our sovereignty, and imposing settler forms of IP onto our sonic world, our creative worlds, our generative worlds could have devastating impacts. As Glenn Coulthard has recently said, these kinds of European descended modes of governance would tend to erase or destroy our connections with one another, with our lands, and even with the cosmos. And so the enforcement of our laws and protocols and standards of care to everyone who occupies our territories may actually improve our global intellectual property systems, right? And make them more equitable and sustainable and bring greater prosperity to our world. So I'll go ahead and conclude there, and I look forward to the discussion.
Thank you, Trevor. That was a great start. Looking forward to discussing some of the things you raised. But before then, I'll hand over to Hyen to talk about her perspective.
Thank you, Jessica. Ta'alafalava malo soifua manlangi ma. My name is Solomon Malo Se'o Malo Fatapepe Me Nime Tualima. Solomon Malo is my chiefly title from my maternal side in Apia, Samoa. My name, which I said my full name, I realized that it could be like a whole paragraph, but I say it intentionally because it reflects both sides of my family. That is my father and my mother's side. My chiefly title, Solomon Malo, could be looked at as both traditional knowledge and a traditional cultural expression. But from a Samoan perspective, or from my people's perspective, it's more important than that. It illustrates my connection to where I'm from, my village, who my family is, and it also represents who I am in my community. So currently I reside in Aotearoa, New Zealand. I'm a senior law lecturer at the Law School of Victoria. But Samoa is my original home, or as I like to think of it, as the hub of the South Pacific. So for Samoans, prior to colonization, knowledge circulated in Samoan society according to relationships. That is, who our families are, in accordance with the village council or the village whānau, and relationships with our gods, and in accordance with how a particular ritual or ceremony is practiced. So for example, the ava whailoinga, or the welcoming ava, or the greeting ava that's done when you enter the village between those who are from the village, the chiefly titles in the village, and the families that are represented, and someone who's visiting your village. There is a way that this is practiced that illustrates who are the families that are there in that particular village, so the genealogy of the family, and then also acknowledging your gods, but then also acknowledging where the other person's from, so that person's genealogy. So we still have this practice of the ava ceremony today. There are slight, obviously contemporary forms of how that is practiced now. So post-colonization in Samoa, we have established plural system of governance. That is, we have Westminster institutions running alongside customary institutions. So in the space of intellectual property, we have what our intellectual property legislation and other relevant legislation, as well as the IP office. At the village level, we have village institutions, the village whānau or the village council, who regulate access to knowledge in the village and also govern how the village operates on a daily basis. So to illustrate the point further, as part of my PhD, I conducted field work in Samoa over 2 periods from 2019 to 2022. So using the Talanoa research methodology, an Indigenous inspired methodology, which reflects Pacific methodologies, I interviewed over 57 participants from Apia and Savai'i. Participants consisted of relevant government officers, knowledge practitioners, and commercial operators, and village participants. So using this method, which is similar to a narrative approach, my role as the researcher adapted according to the interviewee. That is, as the co-researcher, I would problematize the research subject, or there would be a transformative healing process that would take place focused on solutions of the research subject. Or as an empathetic listener, we would mutually come to an understanding of how the research subject would be looked at. So my role as the researcher in carrying out this work was central to being able to centralize the voice of the participants in knowledge construction. That is really being able to give authenticity to the different perspectives that were being shared. One of the interesting findings of my research is that unless you were a government officer or a commercial operator who was familiar with intellectual frameworks, the concepts of intellectual property or legal protection that's provided under intellectual property has little to no relevance to how traditional knowledge circulates in society or how it is protected and preserved. So this brings me to the question of, so what is relevant if you're not familiar with the intellectual property framework? It's about how knowledge relates to the relationship, relational connectedness, understanding that knowledge or traditional knowledge is holistic. It's not something that can be separated out into property rights as such. It's how knowledge is being expressed. Who is expressing it? What is your relationship to that particular knowledge? And most importantly, it's about cultural survival. So I'll end it there, and I look forward to hearing from the other panelists and discussing some of these issues. Thank you.
Awesome. Thank you, Hyen. I won't attempt to say your entire name. I have before, and it wasn't with the best results. So I'm going to hand over to Virginia now.
Maranyaria, Baladu, Urajri Nyemba, Yina, Urajri Nyemba, Yina. Nuramba. Good morning. Good morning, everyone. I'm a Wiradjuri Nyemba woman, and I come to you from Dharawal country today, and it's just a beautiful sunny morning in Australia at 7:50 a.m. So I just wanted to let you know, I'm very happy. Thank you so much, Jessica, for inviting me and many of my other colleagues. That's really wonderful. Look, I think that this is just a great discussion, especially based on even being invited and looking through the agreement today, which is the attendee agreements. An example of organisations, institutions, and it doesn't matter where they are in Australia or whether they're commercial institutions, is that they actually also bind traditional knowledge holders, Indigenous people, to a range of agreements. For example, today we see that universities have absolute and irrevocable right and permission to use our audio recordings and our videos from panels and work that we provide freely and with good intentions. So we have to look through our own institutions. This is really one thing. And attending today, I was a bit alarmed because I think we don't often look at our own place. We don't look at the place that we study or teach from and really concern ourselves with what agreements are being made, even agreements with our own staff. That's also very important to ensure that traditional knowledge holders who come into institutions and are honoured and respected in the agreed word and understanding of their position, their Indigenous traditional positions. So I think we're a long, long way from really getting finality from these issues. In ANU, for example, the Australian National University, where I am, I started off as a postdoc there for 5 years with the School of Science and Regulation and Global Governance. I'm now on a further contract with ANU as a research fellow, and I was very fortunate to get an Australian Research Council grant, which is prestigious in Australia. And that was something that I'd worked on as a volunteer practicing lawyer with a community in Australia. And it was really frustrating because, as we've said so far in our panel discussions, there is no true protection for Indigenous knowledge, especially when it comes to traditional knowledge. And my concern was also medicines, and the concerns of the community was also medicines, how they could protect them, how they could ensure that those medicines were in the community. Some communities decide not to commercialise, but others do decide to commercialise various plants, foods, medicines, etc., bush foods. And the problem is in Australia, we don't have very good law. We don't have very good protection. And it's basically left to private exchanges of contract agreements, and also the writing in of provisions, clauses, etc., which bind those individuals. So in this medicine project that I'm actually looking at, it's Indigenous-led medicines, and it's also trying to really work out how we can establish a framework that is fit for purpose for Indigenous peoples in Australia. And we don't have one, funny enough, after all of the COVID years that we've had in the last few years in Australia under the TGA, which is very similar to your FDA in America. So it's Therapeutic Goods Administration. And they don't have a framework for Aboriginal and Torres Strait Islander peoples. So basically, it's a case-by-case basis, which is not the way we really want to go forward, because we have a lot of issues then that there's not consistency. And that concerns me not only as an Indigenous woman, but it also concerns me as a practicing lawyer in my own firm, because we talk much about intellectual property, and Trevor's pointed out, you know, there's so many inconsistencies. There's enforcement in a Western sense, but then on another side of it, as an Indigenous person, we know that there's also punishment in a cultural way. And we've seen many examples of those across the world, from artifacts, belongings, a very important belongings. I can only stress that word from Aboriginal and Torres Strait Islander people and Indigenous people across the world, that there results a catastrophe or a sickness. So, you know, there's all these different understandings and realities of punishments, but it really is a concern when we have an intellectual property system that will never align itself with Indigenous knowledges, will never align itself with an understanding, as Jessica pointed out. I have a particular issue with rights of nature movements that really want to only talk about Indigenous wisdom, but we often forget that our system of land management, water management, philosophy, understanding our peoples through our creation stories, has been said today, is such an incredibly complex and unique original system that it's quite understandable why the Western system, which is so young and really it's not competent as it stands today in any country to really protect and govern, or even provide any governance for Indigenous people. And we've seen that in many issues to do with individual contracts. I sit on the ethics committee at the Australian National University, and I'm always frustrated how people can opt out of their moral rights or their legal rights in a contract when they're contracting research, for example, on country. That's concerning. And what came out of my past years of being on the ethics committee is that now I'm in a position where I'm leading as a chair, a committee which is all Indigenous people, and that will be wonderful to actually have in place, because it will be a system of guidance for researchers who really need to have a very clear understanding that it's not about their research, it's about community being whole and being respected, and that certain areas and sites or knowledges aren't included when they're asked not to be included. I think that that's something that we all really need to hold on to, because I've written about water and water rights, not only cultural water rights, but also more broadly how it's intertwined with our land and, the sky above, the earth below. That's how Indigenous language groups understand this relationship. And at a particular presentation that we had in Siena, Italy, with Garn and Elgar, it was really interesting that, when you put across that these ancient cultures that predate all the Western legislation and the understandings that we have are still not today understood in the way that we interact with them. We shouldn't have to be on a panel to explain the most ancient cultures in the world. We should be having people come on from Western cultures saying, well, how can we learn from you? I mean, that's really what it is all about, is how do we learn from Indigenous peoples without appropriating the knowledge? And I think that is the biggest issue. And I'm seeing this is going to be an exciting few years on this particular research grant, and leading this is also really a significant breakthrough for Indigenous people, because we don't get that opportunity to have research that's is really going to make incredible differences in communities. But it also is a huge responsibility, as all our panel members know, because we have to do the right thing. We have to travel safely. We have to travel respectfully to everyone. So I'm really excited about this conversation, and I really encourage you not to just think this is the end of the conversation, but it's really the beginning, and Jessica's made a really safe space for that to happen. But my comments would be, in closing, that really look into our own institutions, look at those agreements, look at those contracts which say that they protect intellectual property of Indigenous peoples and recordings and knowledge, etc. That's really important, that you start in your own place of learning and work, and then also inform communities, so when researchers come, they can ask the right questions. They know how to be very certain of their rights and responsibilities in a very different system that may not have any punishment for a breach. And that is something that I have to be aware of, because the control of third parties outside a contract is very hard, not only to identify, but it's also hard to enforce. So I really encourage you to stay on board and listen to these conversations. And thanks so much, everyone, so far. And thanks, Jessica. Manangu.
Thank you so much, Virginia. And I'll give the floor to our final panelist, Amanda, before we go into a discussion.
Kia ora, Jessica. Tēnā tātou, he me nui kia koutou, mō te kaupapa o te rā. I'd just like to acknowledge Jessica for her work on this, and the rest of the panelists here. I'm Amanda Black. Like Jessica, I'm based in Aotearoa, New Zealand, but in the other island. I am an Indigenous researcher, currently a professor at Lincoln University, and I run a Centre of Research Excellence. And it's I will come to that later, but it is, I'm Western trained as a scientist. I'm a Western trained scientist, but I also work back home in my Indigenous communities, and I work with in New Zealand and other Indigenous Māori communities in New Zealand. And I think, I've been listening to everyone's discussions, and particularly Jessica's introduction here. I do have a PowerPoint, but I think maybe I could just actually talk to the key points I think that people have been raising, some specific ones that Jessica pulled out that's relevant for us, but also some of the universal ones that others have touched on. There's three, lots time packed, lots of, I think, movement in this space. Perhaps it's not landing in the places it should land. So coming back to one of Jessica's comments around Indigenous knowledge and having to constantly prove its value or its worth, in the Western science context. And that's an argument that's quite recent in New Zealand here, and one that we've had a bunch of international people, I guess, jump on this for whatever motivations, and and they contest that Indigenous knowledge is something that's of a lesser quality or has less to offer some of our environmental issues that we're facing, which is which is an odd argument to me, because how knowledge is generated isn't really the issue, it's how we utilize it which matters. But it comes back to what Jessica was talking about, like proving its worth, and in the IP sense, which is a very Western construct way of protecting ideas and the products that come out of the ideas, which is what I work in. But me and others, Indigenous researchers in this space, I mean, we span that they talk at the high level, what does it mean to decolonize research methodologies, and it's all really fun, but it's very, very hard for us to, I guess, land it in practical terms. What does this mean going forward? And I think that's what we're trying to do in the research group that we've got here. What was the other points? And part of that key is, and these panelists know, is protecting Indigenous communities, their ideas, their knowledge, their culture, so that the exploitation does not continue, and that they're able to benefit from co-development and collaborations with research institutes and researchers themselves. And IP constructs, well, again, are they fit for purpose? Not really, because what they do is assign everything to an individual or an institute, and it's about the product that's produced from that knowledge. And so that does not fit with the values that Indigenous communities have in New Zealand about ownership and who benefits from what's, and the purpose that you're actually doing it for. And I'll talk a little bit, I guess, about the work, so it might help put things into context. Our Centre of Research Excellence is a multi-institutional, multi-researcher. It has Indigenous researchers, has Western trained researchers, but we're all working towards the collective of protecting our productive landscapes. New Zealand is very primary production focused, also has a very much a conservation focus as well. And there's been a lot of talk about, we also different, we have a Treaty of Waitangi, which Jessica knows and part of her research, and that it's disputed about how, I guess, some of the granular detail around that. But from Māori, from how we see it, it's about having that authority to govern ourselves alongside British colony government. But that's been interpreted differently, and so it's been interpreted more as like a partnership, as a power sharing, rather than the ability to self-govern. And so I guess that's what we kind of work towards in our research, because although the treaty is really an agreement between mana whenua, or people on the land, and the Crown, it's not an agreement with researchers and communities, but because we receive public money from the researchers, we have to respond to that in ways that matter. But for us, that's the bare minimum. So what we're trying to do is really be authentic in our co-development and I guess access and benefit sharing of the research we do. What makes it tricky, though, is how we do this in a meaningful fashion, and what policies and agreements that can be put in place that has that kind of adequate protection that we're talking about. The way we've set up the core is that we're very much based it around Te Ao Māori values. And so the difference in Te Ao Māori values versus, say, Western research values is that Māori view everything as intergenerational. So that's the time frame we're looking at. We're looking at 1,000 years kind of impact statements. And we're all about bringing everything together and sharing in a respective way that's governed by the laws of kawa. So if we were on a meeting house or a treaty ground, that's how we would behave. So it kind of covers our code of ethics or behaviour in that way. And we do have what we call a cultural authority agreement. So when we do work with communities, and we do have communities of interest that we partner with and that we co-develop some of our research with, not all research is adapted to this yet. but that doesn't mean it can't be in the future. But we understand when we're working with these communities, the relationships we have, the expectations we have, the data sharing, and where the research goes towards the end of it. And our researchers have, I could pull up a picture which might help. I think I'll just leave it at that, otherwise we'll get into a different, anyway, we'll get sidetracked. But I make sure that all our researchers have cultural competency at a certain level. And so we bring them onto our traditional meeting houses. We go through the expectations. They understand what's expected of them. And we have these agreements with the communities there that, and so we at the heart of it, it's developing that trust and relationship that we have. And I think that's what we need to do at that grassroots level, to be able to trust each other enough to, I guess, to work together towards common goals. And for us, a lot of that research is built around not only the ideologies of Māori and the values, but also how they would frame up some of our research themes. So our research themes are reflective of what traditional meeting house would be, so that when we go out to the communities, not only can they understand where we're coming from, but we can understand how our research lands and fits. And we're very much like, our research covers is quite a spectrum of science. So it has the molecular stuff with gene editing, but it also has the sociology and the behavioural psychology, governance and Indigenous knowledge in there. So it's a breadth of knowledge and disciplines sort of working together for a common goal that is productive landscapes under Te Ao Māori values. With a definite community focus, because I think that's key in all of this, is like, how does your research land? How do you work with these communities? And so that you can work together for that impact that you need to have. And I think that really grounds the researchers, that you got a clear line of sight of that impact that you're seeing. Now, the biggest barrier to this is probably your institutions that you work in and their response to who owns what. Researchers can have the best intentions and they can develop the relationships with the communities, and we can have cultural authority agreements, and we can have access and benefit sharing agreements. When it comes to the pointy end of contracts, it's the institutions that decide who owns what. And so at the moment, we have what we call a mana oriti agreement, and that is really, it can be a legalised form of, I guess, the reciprocation of any sort of benefits that come out of legalised, yeah. So it's really, it covers data management and the production of data from data. So we've tried to, with the mana oriti agreement, we've tried to cover everything that could possibly come out of the research that we're doing with the communities. But also the key with this, it allows for a treaty-based disputes resolution. And so really we've tried to give this, the control back to the communities rather than institutions. However, our biggest pushback really is the policies and the institutions themselves. And so I think that really, really needs to change, and we can, and that I think is at the moment our hurdle for getting, real quality research relationships with communities and Indigenous researchers on board, is having that protection in place. I mean, I could touch on a whole bunch of other stuff that Jessica brought up as well, improving the knowledge, Indigenous knowledge versus Western science, and that kind of thing. But I think that it might be helpful if, we just come to question times and we can discuss that, because that's a whole nother side issue there about, cherry picking to suit your argument or your point of view. And we've seen this in the past, where particularly around conservation, when they, you get popular scientists like Richard Dawkins saying, oh yeah, but Indigenous Māori ate all the moa, so they can't their knowledge can't change, it can't be reflective, we can't learn in Indigenous knowledge systems. Whatever was developed 500 years ago, that's set in stone, unlike Western science, which can learn from its mistakes. That's an example of cherry picking and just blatant racism in those statements. People like that know better, but they cherry pick these kind of arguments, to continue to support their points of view. And that's what we're seeing through this and this war of rhetoric as well. That would be my key points, is like, how do we get our institutions to respond in a way that's going to be reflective of what we need going forward? Thanks.
Kia ora, Amanda. Thank you. Thank you to all the panelists. And I think I will start the conversation with your final challenge. Like, how is it that we get institutions to engage in a genuine way? So you've raised this, Virginia did as well when she spoke, and she talked about simply the agreement that we all had to click on in order to register for this webinar. So how can we go about engaging with Indigenous peoples in a genuine way that isn't just box ticking? Maybe I'll ask Trevor, do you have any any thoughts on this?
Sure. So how do we engage with universities? I think some of the most important things that we can do, I think, are, like was said, building relationships that are on equal footing. One of the major principles of restorative justice theory, for example, is that you don't enter into a reconciliatory or a relational process when you have an unequal power imbalance. For us in our communities, that means that somebody that enters our lands to do research enters into an agreement to be subject to our laws, subject to our justice system, and that all of our protocols, laws, standards of care, all of those are applicable to them. If they violate them, then they're subject to the kinds of consequences we have. So, I think that's the first step. And I think the other points that were reiterated today are, I think, fantastic, which is that, we have that dialogue, we have that exposure, we understand the motivations of one another. I think the people that work in my community have to understand the nature of the materials that they're working with, not just, from their perspective. I remember as a young researcher, even in my own community, I was asking about music and, why do we create music? And, music was the focus. But what I didn't realize is that what I thought was music was actually something very different, right? The nature of it is very different and had different connections to people and to things. And by thinking of it as music, it kind of flattened it ontologically, or flattened it and its real relationships. And so I think that's another step, right? Being able to listen enough to understand the real relationships and the real nature of the things that we're looking at. And if we don't do that, we end up cutting them off from their relations. And that, I think that could be devastating. So yeah, I would start with those two, right? Equal footing, and then really understanding the nature of what it is that we're working with. But I would go ahead and pass the baton to anyone else who wants to add to that.
Yeah, I think that's really true, Trevor. The most important discussions we sometimes believe is just getting through all of the different areas of agreement with our institutions. That's the spiky end, as Amanda said as well. Because many times, and I know this as a practicing lawyer, the legal departments have no understanding or very little understanding of Indigenous knowledge processes, and Trevor has pointed some of his own out. So, those repercussions of breaches and also how it's dealt with, we usually have a clause of mediation, or we have a clause that no party goes to court, and that's a very strange process, because we're saying that traditional knowledge is very important. We might slip it in there as a clause or a provision, but the process of delivering a proper processes according to the communities that you're visiting is bereft in the institutional agreement. So I think it's really important that we have people not only in the ethics committee that are Indigenous, and I've found such a great progress is just being able to say, well, no, this particular application has problems. It must go back. It must go back thoughtfully so we can actually rectify some of these ideas or lack of benefits or lack of processes, or even when we turn to the literature review on many of these applications, there's no Indigenous reference to any scholars who are Indigenous or processes from the community that are Indigenous. So I think that we have to really look at the ethics, and the ethics, I'm talking about the community, not the Western ethics, but the protocols and Indigenous ethics that need to be really well thought out. So it needs to happen in that process as well. And when we come and talk about access to benefits, in Australia, we haven't ratified the Nagoya Protocol, for example. And that's a very big issue because we don't have consistency for communities. There's no consistent access to data that we can say that all communities are being fairly treated and understand what they're signing, understand why research is being done on country and how they can push back if necessary. So, when we talk about Australia as a developed nation and we haven't ratified that Nagoya Protocol, that's a huge impact for communities. If we have access and benefit sharing agreements and they're just individual contractual agreements between an institution and a community, no one on the Indigenous side could even imagine that there would be, 1, 2, or 3 lawyers sitting in a community going over page by page, 30 pages, 40-page agreement to ensure that fairness was going to be at the top of the list and culturally appropriateness. So, we have to understand that those situations, just merely having an agreement means that it is going to take a lot of money as well as people acting pro bono to assist communities when they fall foul of a particular provisional clause. So, it becomes a nightmare for communities to have to even think of these things when it's a very different headspace. It's a different mind space. It's a different heart space. So I think that we really need to get down to the big issues because, as Amanda pointed out, our institutions can be the biggest problem. And we know even today there are bones and artefacts of Indigenous peoples from Australia that are held in so many institutions across the world still in 2023. So we haven't advanced fully on that front, but we also haven't advanced in our legal departments, in our institutions who need to conform to a well fit for purpose Indigenous method of doing business. And we have some really great thinkers on these issues. Thank you.
I might ask Cayenne on her thoughts on this. I know she's written quite a lot about access and benefit sharing agreements in Samoan context. So you could share your thoughts, Cayenne.
I agree with what was said there, Trevor. But I think one of the issues there with access and benefit sharing agreements is it promises a lot that doesn't necessarily eventuate. And I think that with an access and benefit sharing agreement, when you're looking at the model, there's actually a lot that should happen in the community much before we actually result in an access and benefit sharing agreement. In fact, there are issues around, as Trevor had mentioned, building the relationship. How does that look? And then also how you're accessing the community and the consent. How does that look? And if you look at it, say, in terms of process, it goes much more beyond the concluded ABS agreement between the two parties, the holder of the knowledge and the user. And, you know, the Mamala example that we've looked at in the past, it's pre-CBD Nagoya, and it's held out as this perfect example. And the reality is, it looked great on paper, the promises looked amazing, and it hasn't eventuated. Yes, we now have the canopy walk, we have some benefits in the community, but in terms of the long-term effects and the long-term term benefits, they actually haven't flowed into the community, you know. And so you have, you know, total appropriation of knowledge. Community no longer knows where it's gone. It's totally out. Government has no idea where it's gone. So that's why I really, I think it's really important in ABS agreements to firstly build a relationship, you know, and actually ask the knowledge holders, what is the significance of this knowledge and what is it that is important for you to have protected and preserved? And then make sure that when you're, you know, having the consent of the community, that's true, genuine consent. And that's, you know, and also like eventually you will get a patent out of this. You know, the last side of that is that the patent, the timing of it is so important because IP rights only last for so long. So that's why I'm saying that there's little processes that can happen before, which can actually be other minor contracts, but actual genuine engagement with the community, not promising things that sound great, but won't actually eventuate. So I'll just get off my soapbox there.
Thank you. It makes me think of what Amanda said, that our Māori perspective of you're thinking about 1,000 years, right? And so you're thinking about long-term relationships. We're talking about long-term trust. And the reason why there's a lack of trust is there are so many examples of Indigenous land. And as Virginia said, human remains, things, now cultural knowledge being taken. So there's a lot of mistrust. So it's why there currently is a lot of discussion around, well, where does this data go? Are you recording me? Where's it going? Where does it sit? And in New Zealand, there's a lot of rhetoric, discourse around data sovereignty. So Amanda, I might ask you to speak to that if you'd like, about your thoughts about where does the data go and who's actually possessing the data?
Yeah, there is a lot of discourse around that, and still a lot of uncertainty because it very much depends on what the data is and what's it going to be used for. I think, for example, like some of the research world that I work in, and I've got to come back to the access and benefit sharing. I agree. I mean, I've got Indigenous researchers doing access and benefit sharing, and it's always, to me, it's oversold, right? I've never really seen the stuff that comes out of it, all the frameworks and all that other stuff. I mean, it never translated into the promises it was supposed to have. But coming back to the data sovereignty thing, like I can work in the genome space. I'm dealing with environmental samples, and some of the issues that we do, like the communities that I work in and looking at biosecurity issues, is that, you know, every time you publish, you have to submit the data into a public space. So that can be, in theory, you know, it can be used, and it can be for the good of science. And we know that the good of science only really benefits a small percentage, right? And what they're developing at the moment, a platform called Genomics Aotearoa, is one that has that Indigenous, other Māori angle to it, so that there's a custodial effect, I guess, if you submit it and Māori communities submit it, and if anyone wants to access it, they have to fill out a form saying what they're going to do with it. And so that's one way of dealing with it. But see, that kind of database isn't accepted by international journals. They only like the public ones, the health ones. And I don't know, and I'm guessing that's going to be a slow cultural shift as it, you know, filters through the international research community. But here in New Zealand, I mean, that more and more that's going to be what it looks like. I mean, there's a lot of pushback that, you know, it's going to slow up research. We're going to, you know, be behind the times in terms of international publication machines, because that's, you know, that is our currency as researchers. But I think that's the ethical way to go. It's the right way to go. It's going to be the slow way to go. And as long as we accept that, and government funding policies and funding mechanisms recognise that, then I think we will get there. It's just, there's a few policy issues around research funding that we have in New Zealand that promotes this kind of behaviour of not being able to develop meaningful relationships, because we're on 3-year cycles. It's like now, you got to go out, you got to discuss, you got to consult, and none of it's meaningful. And the fact is that you never know if you're going to get funded. So all these communities have been hit by researchers having to engage because of the policies, and so that itself, you know, adds to the issue here. And it's multiple issues that has to be dealt with, yet at an individual level, but also at that national policy setting level and internationally in terms of the requirement around data. I don't know if I've answered your questions, but I've kind of just discussed some of the issues that are out there that, you know, the bottlenecks, I suppose. Yeah.
Thank you. Does anyone want to add to that?
I'll just add quickly, Jessica. I think, you know, that's one of the issues on the forms, and Amanda's pointed this out with data. And what is data? Is it the raw data? Is it the aggregate data? You know, there's so many different forms of data, and communities not knowing where a particular data is stored and how they can get access to it. If it's overseas, that makes it very difficult. So, you know, we have the Australian Torres Strait Islander Institute, which is run as an Indigenous institute in Canberra. And I do know that of all places, as an opportunity to store data, that would be, at least at this time, a priority. But many other accesses to this data by community is discouraged. Especially ones that are also very, very difficult, and not only to give your research to, but also to monitor it, and who's accessed it. That's the thing, who's accessed your data. And I don't believe at this time, especially in Australia, that I've seen any example that has occurred. We don't have that information coming through. And I think even to the point of understanding what research is being undertaken. I know when I look at such of the many language groups across Australia that, you know, how on earth can small communities without the capacity to monitor these things even try to understand where that research is going, and where is it going off to, and where is it being read by, and where is it being misappropriated by? Well, Indigenous communities just do not have that ability to undertake those inquiries. And the community I'm going to on Saturday is part of the research I mentioned about medicines. But, you know, I think about the homelands there might be 10 people. 10 people, it's impossible. We can't even fathom how communities can protect their knowledge. So I think, you know, there's a lot of things that are thrown out there today. We've heard some very insightful, intelligent discussions about, you know, just the problems of existing in a Western system. And actually, we are really headlining. We're delivering the best system, the best understanding of how to do research, and we need to be really, our communities, in control and management of those things, and especially the young ones. You know, those young people, the primary school children and the high school children on our communities. They need to really be prepared with the right knowledge on the Western side on how to deal with this without being consumed by it. You know, we need to retain our identity and our faithfulness to that. So, you know, I can see so many wonderful and rich conversations today, but I think it's just the beginning.
always find it interesting that we've been talking a lot about the use, appropriation, exploitation of Indigenous knowledge, how to protect it. So clearly it has value. But on the other hand, we've also been talking about how it's somehow not given value in the eyes of intellectual property. It's like this invisible thing that actually often can't get a patent, isn't recognized by copyright, and so on. So I want to ask a big question, which is, well, then what is the role of intellectual property? Because you all said things, all four of you said something to indicate perhaps intellectual property isn't very relevant. So Hyen, you talked about the fact that at the village level, it's in no one's mind at the village level. Trevor, you said that imposing IP could be detrimental to Indigenous groups. Amanda, you said, oh no, sorry, Virginia said it cannot align with Indigenous systems, and Amanda said it is not fit for purpose. And instead, we've actually kind of talked about private means of trying to deal with the issues. So contracts, essentially, a private thing. And we've talked about grassroots movements and so on. So for you, in your minds, what is the role of IP here? And maybe not IP as it is. Could IP somehow do something different that would be not detrimental?
Should I jump in?
Thank you, Amanda.
Look, I think IP comes from, like a lot of other concepts, comes from a very commercial, very westernized viewpoint, and it's just been, it's an umbrella thing that's gone out to everything. And there's other types of law or policy I can think of that, and it hasn't adjusted. It's not a flexible, like I find law, it's not very nimble. It's very, very slow to respond to the dynamics that we see in society. And I guess that's how I see IP. I mean, in theory, it could be beneficial to protect the rights of Indigenous communities and their knowledge. Most of the time it's weaponized against them. But that would have to go back and look at, I guess, the fundamental, the framework of which it sits on, and I guess it would have to be, not fit for, so it would have to be revisited so that it is fit for purpose, so that it is to protect exploitation rather than weaponized against these communities.
Thank you. Trevor, do you want to follow up?
Oh, sorry, were you calling on me?
Yes, please, if that's okay.
My kids just came home, so it's a little loud. So I guess what I would say is I see IP as being useful in at least two ways, right? There are some, because Indigenous ways of approaching, things like like traditional knowledge, traditional cultural expressions are so varied. I've certainly come familiar with some Indigenous communities whose modes of circulation are very close to copyright or close to patent, right? And thinking about creativity and innovation. And so for them, I think it may not be a natural fit, but there are ways to kind of tweak a few things and make it work. I've certainly seen other communities where it's diametrically opposed, right? It could be harmful. So I think communities have to make judgments about the alignment of different regimes with their own modes of circulation, creation, standards of care. I think the other useful thing about intellectual property is that it is in some ways, and kind of unfortunately, a lingua franca amongst people in industry and across the world, right? It's a mode of intellectual governance that many people understand. And so in terms of like its leverage, I think there's ways to leverage it to require certain things. And so, as an ability to exclude others, it can be very potent. And so if an Indigenous community wants that ability to exclude, it can be useful if it applies. But I think it, like any other tool, it has to be used really strategically and carefully. And if there are ways to leverage it, but I think Indigenous peoples have always been creative and have been able to make use of what's been given to them or what's been available. And so for those that feel like they can use it and can use it productively, I say, yeah, go for it. If you feel like this is actually going to help you accomplish your goals, sure. At the same time, I think it requires a lot of care and a lot of kind of untangling, right? I think there's a lot of thought that has to go into it. Now, certainly IP can be constructed in different ways. Licensing agreements can be constructed with conditions on them. And I think making use of conditional language in granting clauses of IP agreements, it can be very, very useful, ensuring that, those rights are limited to just if compliance is met, right? Certainly in my community, I wouldn't want to have anybody license any of our knowledge to a university without a conditional clause saying, well, so long as you abide by this and this and this, and you're subject to our tribal legal system, and you are willing to be subject to our jurisdiction and our courts, I feel a little bit more comfortable then. But without those kinds of conditions, without the ability to revoke, I don't see a useful way forward in a lot of contexts. So, I mean, I agree. I would agree with what was said earlier, that internally within our community, copyright isn't useful and it isn't known, and certainly internally circulating information and knowledge and things like that. Nobody uses it or talks about it. But when we talk about outside of our community, people often jump on and say, hey, this person's use of my knowledge violated my copyright or my trademark. And they expect that their IP can function as the boundary line or kind of a marker that says to everybody else in the world, keep off or ask my permission. And so, yeah, so I have mixed feelings about it. I apologize for the long-winded answer, but yeah. That's where I'm at.
No, thank you. I'm actually going to read out something that you wrote, and then I'm going to ask Haiyan to comment on it, if that's okay. So you wrote in one of your articles, colonization has kept tribal nations from enforcing their intellectual property rights within the borders of the United States and beyond, instead requiring them to become dependent on copyright to protect and promote their work. And obviously that's slightly out of context, but it struck me that use of the word dependent, that by kind of replacing a local system, a community's legal system, that group can become dependent on it. And I know that this is something that Haiyan has thought about in the Samoan space. So Haiyan, if you wouldn't mind talking about that, about what it's like in Samoa having a very complex system of your Indigenous, the Samoan rules, and on top of that, like these intellectual property systems.
Thanks, Jessica. I think, as I alluded to earlier, it's very complex in Samoa in terms of, on the one hand, you have IP laws that are operating that have been enforced or been imposed, if you like, by international organizations such as WIPO and WTO in order to meet Samoan Samoan obligations to international standards, but also for us to be able to have, because we are a least developing country and still developing, in order for us to have access to funding. And so it's a catch-22, or if you like, where the country needs this money to develop, but on the other hand, these laws that are being imposed, these workshops, these seminars that are being imposed, really do not touch on the actual issues on the ground. And like with my research, that came out as one of the things is like, as Trevor pointed out, is intellectual property is only relevant to the extent when there's an outside coming in or when there's a commercial benefit you know, and sorry, I'm probably going off on a little tangent here, but what I'm trying to get at is two things effectively. Firstly, because of an imposed intellectual property system through international obligations, we have a system that can be useful. I'm not anti-intellectual property. It's not that. It's what I'm saying is that it can be useful. Where it's useful is where there is a commercial benefit or there is a way to protect your knowledge, but it's not something that you use in isolation. It can be used with other aspects of law, but also other aspects of who we are in our own communities. So one of the issues that really comes out with imposing IP frameworks from the international level into the national level of Samoa is that you have an established system. Those who should really benefit from it are not engaging. So you've got a waste of resources. Secondly, the issues on the ground look very different, you know, and if those resources were actually put into the national level to actually help the village develop how this knowledge is, or to work with how their system should look, we would have our own protection. Like I hear what Virginia said, that, you know, it's quite a cumbersome process to put on a community to be able to regulate who's accessing that knowledge and whatever. But as researchers, we have the responsibility to actually have that conversation back here before filing, you know, our research applications and everything. I hope that answers your question, Jessica.
It does, thank you. And I think we could talk about this for a lot longer, but I will now take some questions from the participants. So we have 3 in the Q&A channel. I think the first one we've already kind of looked at, so talking about like, well, what is the role of IP in this space or these different contexts. So I'll go to the second one, which is, I actually don't know who else can see these, but in any case, there are 3, and I'm going to the second one. It says, thanks so much for this panel. I am in Canada. I am interested to know from Trevor whether he has seen contracts that integrate protocols and standards of care into contracts between Indigenous artists and presenters in the case of performance or government commissions of public art.
Well, I really appreciate the question. And I think we're starting to see more and more movement along this path. As was already mentioned by several of the panelists, we've seen benefit sharing agreements happening, especially in kind of the traditional knowledge space. When it comes to cultural expressions, I think we're seeing more and more care being paid to the way that Indigenous peoples express and want their knowledge to be expressed in public spaces. This is actually a project we're currently working on here at Arizona State. We're working with some of our local communities to develop these kinds of agreements dealing with cultural expressions, oral histories, song, knowledge, things like that. Developing ways to be able to share this according to local protocols and standards. I know that some attorneys here in the US have been working on this, so I'll do a shout out to Big Fire Law, Mary Holmada, who has been working on agreements like this. And so I'll point out her work, and I know that she's been kind of keeping tabs on agreements like this that exist out there in the world. I'll also point to local contexts, the Enrich hub that they maintain. They've been working on kind of licensing structures, and I think there's a lot of promise there. But I have to say, this is an area that is we're desperately in need of more examples and more conversation about how to actually execute these ideas. How do you draft compelling, conditional licensing structures that actually require people to pass through protocols in order to have access to Indigenous cultural materials, cultural knowledge, cultural expression? How do you, embed protocols or at least supervision over the performance of things in order to ensure that they're done with care? Should there be some sort of tort liability if the appropriate standard of care isn't actually followed through with, right? I think we've seen some really interesting and innovative approaches, even in Canada, right? With the Louis Riel opera that was recently performed, the Nisga'a Nation required that opera be rewritten to include, to remove an offending piece of song that was embedded in that opera originally. And so a new composer was commissioned to rewrite that portion of it. I think that's a very interesting, and the agreements that went into that, I think would be very interesting to look at. But I think we're on the cusp, and I think this kind of the private law aspects are going to be very interesting to look at in the area of cultural expressions, in addition to what's already been done by our panelists here to create these kinds of agreements in the traditional knowledge space. So I'm actually very interested to hear more from others here about that.
It actually ties into another question, what you've just said, and actually what has come out of a lot of this panel, that it seems like IP law is this static thing that's not going to change, or not going to change very much. Instead, we have all these private agreements. We've got frameworks, agreements, protocols being used to try and achieve what Indigenous peoples want. So we have a question that says, not to put anyone on the spot, if intellectual property has no real role, what should the WIPO IGC be doing? So that's the Intergovernmental Committee on Indigenous, I can't remember exactly what it stands for, Hyen will know, genetic resources, traditional knowledge, and folklore. Like, it's been conducting these negotiations, text-based negotiations, for years. It's meant to conclude one of them next year. Are they missing the point, or what are they meant to be doing?
Can I jump in?
Yeah.
Yeah. So I just actually looked that up, so that I'm sure what I was actually answering. And here's the thing: I found all these protocols, it's like they never filter down, right, to the people on the ground that have to deal with either the data or the products or the protection of knowledge. And so these are very, very high level intergovernmental documents. They're so high level, and in lots of spaces they have no meaning. Okay, so you can't, to have these generic agreements, sometimes you just better not to have anything, because it just doesn't, because traditional knowledge or Indigenous knowledge it's contextualized, it's very contextual based. And to have these sort of international things, well, it's kind of helpful in terms of, I guess, an ethical researcher behavior, you know, some first points to come to if you're starting from scratch. But it just doesn't really filter down to where it should go. And so I think Trevor's point was, you know, if you can use IP to achieve what you need, then do it. But I've never found these big international guidelines of much use on the ground. And maybe there's just that disconnect there from these groups to people on the ground. And maybe that's where we could come in, as make those connections so that it does work.
Thank you, Hyen. I saw you nodding along. Did you want to say something?
Yeah, I agree with what you've said there, Amanda, but I think what WIPO has done, if you like, is it's put a lot of these issues on the map. Whether it has done it in a way that is meaningful and useful to Indigenous people is another question. And that's something that, you know, has written about, you know, in different aspects. But I think the problem with the WIPO negotiations is that Indigenous peoples are the observers within member states driven process. So what does that mean is that Indigenous peoples can put forward a statement with regard to you know, where they see some of the negotiations going, or some of the language they would like in the text. That is subject to member states having approval. So the usual culprits that we've seen in terms of how they stood when United Nations Declaration on the Rights of Indigenous People came through, are the usual culprits that are also stalling these negotiations, because they've been ongoing for over 20 years. So, like I said, two things. WIPO has managed to put these issues on the map, but it's problematic that Indigenous people are the observers of the very subject matter that you're talking about, who should actually drive the process. Yep.
Trevor, did you have any thoughts on this and the US's stance in the IGC?
Well, I don't know if I can say a whole lot more than what was said. I do. I think it is exciting to see the process move forward after so many years, right? After decades, to see kind of, I don't want to say people's feet to the fire, but the fact that there's actually impetus to move forward, that is exciting. But I also agree with others that, is this actually going to solve the on the ground problems at a community level in a way that is going to be meaningful? And I guess we'll have to wait and see what the draft looks like for some of these. But there's plenty more I could say, but I'll leave it there for the sake of other questions.
Okay, there's one more question before we wrap up, and it is, do you have any suggestions for finding Indigenous cultural knowledge that is not protected by IP or can be reused for attribution, with attribution? So I guess it would be a question about a way to be able to find Indigenous knowledge that one can use without causing offense or breaking Indigenous laws. I'll give you 30 seconds each.
Well, maybe I'll just jump in here quickly. I actually, it's an interesting question, and I think AI will end up trying to solve this for us, unfortunately. But what I do think is that we shouldn't be afraid of working with Indigenous intellectual property or structures, right? I think there is a lot of fear in the community at large because, do we understand what's happening here? Do we know the laws and all of that? But I don't think there's as much to fear as people claim. And I think it's great to engage with communities. And I think we all grow because of it. Even if the answer is no, we will definitely grow from connecting and collaborating with communities.
Ian, Amanda, do you agree? I'm gonna take silence as assent, and I'll wrap it up there because we're exactly at time. But yeah, I would add that. So Trevor said at the end, interacting with each other can only be positive, and I know that Haiyan has had similar thoughts before, and Amanda's work also reflects that bringing people together, bringing different kinds of knowledge and ways of knowing together can be beneficial. And perhaps in a similar way, bringing Indigenous ideas and worldviews into intellectual property could be beneficial, because as Amanda said, we're thinking about very long-term relationships, about long-term environmental concerns and so on. And I think Trevor said, or Haiyan said, it's very community focused, their way of seeing the world. So maybe IP would benefit from Indigenous perspectives. And with that, I will hand back to Sandra. But thank you everyone for this wonderful discussion, and to the participants for their questions.